The offers of proof made by the state yesterday relative to this next witness by excluding 1, 2, 3, 4, at least 4 of these offers of proof, which included testimony regarding sharp blades, removal of bone from flesh moved away, the anatomy of a jawbone, and blunt force trauma to jawbone. Is the court saying that it's excluding that those topics?
Yeah, actually, it's good that you mentioned that. Let me first of all say that I am saying that I think testimony relative to the foundation provided by Dr. Laufer in terms of his qualifications as a quote-unquote forensic pathologist are, in the court's view, clearly in rebuttal to that testimony provided by Dr. Laufer. So I'm satisfied.
And I won't argue about those. In terms of the offers of proof relative to consults with medical examiners and those topics, I'm not really addressing those in this argument. I am, however, addressing all of those other offers of proof on the grounds of it being cumulative. And let's just put things in context here. That would be the 4th state's expert to testify on the exact same jawbone and the marks thereon, okay, versus one defense expert.
I understand your objection. Let's see what Mr. Arpo has to say about it, and I'll give you a chance to respond.
Mr. Rivera.
Let's see what Mr. Rivera has to say about it, and someday I'll give you a new name. Anyway, proceed.
Thank you. Your Honor, there's other matters that Dr. Conte,
That's true. You did mention more than the foundation provided by Dr. Laufer, my apologies.
Correct. And one of the other matters that none of the state's witnesses did address is Dr. Alice as a forensic pathologist will address the blood pattern that Dr. Laufer opined is belonging to or as being caused by a condom. And he did in the capacity as a pathologist, although he also did mention a injury mechanisms expert, which that is unclear because he mentioned that the mechanism of injury expert, the way the example he provided was that it was if a child fell and if the injuries were consistent with either fall or abuse, that's something he would look at. So it seemed to the state that the blood pattern he was opining about more or less referred to one, because he didn't have any training or education, I guess it'd be his exposure to forensic pathology, and 2, because his family worked in the garment or worked in the dry cleaners for 20 years. So the state would bring in Dr. Conte as a forensic pathologist to rebut what Dr. Laufer opined with respect to that particular area. Now, with respect to the cuts and injuries, there was one specific cut that the state wanted to bring in addition to the 4 cuts, but if we were to number the cuts lines, or cut 1, 2, 3, 4, as we've done before, this is with respect to State's Exhibit 410. She, as a forensic pathologist, did note that there is a clear-cut line that goes through the flesh all the way up to the tooth area, and she would opine on that as a forensic pathologist. With addition, she also, as a forensic pathologist and not as a forensic anthropologist, she would testify that when flesh is pulled off of bone, and in this particular case the mandible, as Dr. Laufer testified, bone was removed with the flesh. She will testify that that does not happen. And again, she'll be testifying as a forensic pathologist, whereas Dr. Castellacqua testified as a forensic anthropologist. That does not happen. So there's no cumulative effect on that. And Dr. Hall did not opine on that because we've never heard that until Dr. Laufer came in with his shallow credentials and said flesh or bone comes off with the flesh in that area. So the state strongly feels that a rebuttal is appropriate with respect to that shaved area. Again, it's State's Exhibit 410, which is the right mandible, a photograph of the right mandible. One other thing, Your Honor, before we start, because the mandible has been admitted into evidence, we wanted to show have Dr. Conti Diawis provide her an opportunity to review the physical evidence like we did for Dr. Lawfer. But because of evidence, although it was in the possession of Tony Earls, we felt it would be inappropriate to open up the evidence because it's admitted, and we would want to give her the chance to look at that here in court. So before she testifies, the state is going to ask for a short time period when she can look at two things. One would be the specimens or the jawbone and the bones that were sent to, at the time it was called JPAC, as well as a pair of blue jeans that Dr. Lawford gave that opinion on with respect to the blood stains.
All right, thank you. Ms. Ruffalo.
So here we are again. I mean, it seems to me like every word I say is criticized. The state's given an opportunity to give the offer of proof yesterday. They don't make any mention of any blood pattern offer of proof, which to me would be the most significant one that I'd have to prepare for. And here they are today saying, oh, we're going to put on some evidence about blood patterns now. So, I mean, what part about this is not trial by ambush?
Your Honor, I object, because counsel's acting like he doesn't know the rule.
Let him finish his remarks, please.
Essentially, everything that was offered yesterday, when given the opportunity, is cumulative. What is being offered, and let's just put things in context. By the state's own admission, this is of a lady who hasn't even looked at the jawbone yet. But my argument, Your Honor, is that you're asking for a fair trial. The state is now asking for their fourth expert witness to testify about the same thing. We have now entered into a trial about pig stuff. When we raised this issue about pig stuff in their second or their first significant witness in Detective Liu. That's why I bring up Detective Liu. That was the trigger for them to have their affirmative duty to present their case. Not to hold back on their case until the last witnesses so that they can impress the jury the most with their A game. That's holding back their case. Directly contrary to the legal standard that the court is ordered or instructed to follow. So, for the state to come in here today and just so nonchalantly say, oh, I'm going to add an offer of proof here, to me it is a double standard in terms of how representations in this courtroom are taken. And above and beyond that, it just evidences, again, the trial by ambush that's taking place, which ultimately creates an unfair trial, whether by numbers or in substance, or in the amount of resources spent. However you want to put it, the state is basically paying people to fortify their case at this point against the legal standard and in a cumulative manner.
All right, thank you. All right, the court will rule as follows. First of all, as a backdrop, obviously this is we're in rebuttal. Second, Dr. Lawfer testified without producing a report to the parties and testified on a wide range of topics from injuries to various things observed in the jawbone, to his being a pig hunter, to his experience as working with his family in the dry cleaning business, and there's just a number of different fields that he testified to, again, without producing a report. The blood pattern information was a new addition to the case, and accordingly I'm going to allow that as a proper rebuttal. The qualifications issue relative to that of a forensic pathologist, and the court's view clearly is one raised by the defense, and during its evidence in chief and its appropriate rebuttal, the question of the flesh cut in the area of the tooth also is something that actually was raised during rebuttal by the defense. And so in those areas, the court's view is that would be appropriate rebuttal. In his argument, Mr. Rivera refers to, in somewhat of a summary and generic fashion, addressing various issues, but I'm not in a position to say that that's, well, it doesn't really tell me what it is specifically that the prosecution wants to present. So at any rate, I'm going to allow those areas. I think those are all proper rebuttal, and especially in light of the fact that Dr. Loeffler testified without producing a report to the parties, and in particular to the prosecution.
You know, there's one other area that the state did mention, the aspect where Dr. Loeffler as a forensic, or being allowed to testify as a forensic pathologist, did testify that the flesh comes off of, the bone can be removed with the flesh when pulled from the jawbone.
I think we've covered that area.
No, but we did not have a forensic pathologist testify to that. We had the forensic anthropologist, because that never came up before or even after Dr.
But you did have a forensic pathologist testify in your evidence in chief.
No, but she did not address whether bone is removed with flesh when flesh is pulled off the bone. That's something entirely different, and that comes from far off. So the state would need a forensic pathologist to rebut another forensic pathologist who would say such a thing.
Respectfully, I'm going to decline to allow that. To a certain extent, Dr. Loeffler moved into the area of being a forensic anthropologist, although I had some reservations about that, but we've had rebuttal on that. So I did allow that because he did, his testimony did drift into that area, as well as many other fields of expertise that he said he was qualified to testify about. And so I thought that was fair rebuttal. But in terms of forensic pathology, we've already covered that ground. So the areas that I've allowed, are the areas that the court will allow. And
I'm sorry, could I get a clear articulation of those areas again?
Body pattern, qualifications, flesh cut in the area of the tooth. All right.
So does that, flesh cut in the area of the tooth, I'm guessing the state's going to basically get into the jawbone again, and they're going to start with the anatomy of the jawbone and revisit how marks are made with sharp instruments, and then that's how they're going to work up to the flesh cuts, which includes
yesterday the defense raised the question of whether there would be a corresponding flesh cut in the area of the jawbone and the tooth, and that's what we're talking. That's what I'm talking about.
So they get to bring in another witness to.
You folks brought that up.
To add in to fill in for the deficiencies of their other witness.
No. No. They're.
It's cross-examination. It's not my case. That wasn't my case.
Let me say this. That's my ruling. And so that's what we're going to do.
And Judge, I'm sorry, there's one other area that the defense brought up that went unrebutted, and that's with respect to pig markings from pig teeth on bone, human bone. And Dr. Conte, as a forensic pathologist, has experience in that, she has observed that, and she can describe what they look like and how they do not look like the 4 cut marks or the shave mark that is depicted on the right mandible. Again, it was clear that Dr. Pasalakwi did not go into that area with the exception of the discussion of the article, but it's clear that Dr. Lawfer did, and again, as this court pointed out, because there is no report written regarding the pig marks or pig markings on a human bone, then the state feels strongly again that it should be able to bring in someone with a pathologist with that experience to rebut what Dr. Lawfer is claiming to be pig marks in the bone.
Mr. Upall?
They brought in one of 115 prestigious forensic anthropologists to testify relative to that yesterday. That was their choice. Now they want to bring in a second layer. Again, when do the experts stop, and when does it become unfair? They've got 4 experts testifying on the same topic just because we put one expert on and we challenge their defense? Where does it end?
All right, thank you. I will allow testimony on if she can lay the appropriate foundation relative to pig bite marks, and that assumes that she's got the background. Dr. Lawfer, again testifying without a report, testified about his background in forensic pathology, as well as his, ended up testifying about his background as a pig hunter. And so in the court's view, that would be appropriate rebuttal. Those are the 4 areas. Do you have the other witness available?
Yeah, no, he was going to come at after lunch because we were anticipating having Dr. testify first.
Because you're asking me to...
We wouldn't need more than 15 minutes for her to take a look at things.
Yeah, well, this is all time on the clock,
Well,
Mr. Rivera.
Well, I mean, there was no way to do it other than bring it to court. To have her look at it in court because the evidence has been admitted. If it would have been so much easier.
Let's get it done. Let's get it done. All right, we'll take a recess.
Recess.